If you own property in California, or you plan to pass property down to your children, Proposition 19 is something that you need to understand because it has completely changed how property taxes are handled when real estate is transferred. And I can tell you from experience, this is one of the most common issues that comes up when families are doing their estate planning. Many people assume their children will inherit their home with the same low property tax base that they enjoy. But in many cases, that is no longer true. Today, I want to walk you through what Proposition 19 actually does, how it impacts your family, and what you need to consider when doing your estate plan. Before Proposition 19, there were rules in place that allowed parents to transfer property to their children without triggering a reassessment for property tax purposes. This meant that your children could inherit your home and keep your low property taxes. For many families, this was a major benefit, but Proposition 19 changed that. And understanding those changes is critical if you want to plan properly. At a high level, Proposition 19 limits the ability to transfer property to your children without property tax reassessment. Under the current rules, there are only certain situations where your children can keep your tax base. And those situations are much more limited than they used to be under Proposition 13. The most important rule applies to your primary residence. If your child inherits your primary residence at your death and then uses it as their primary residence, they may be able to keep your tax base up to a certain value. But there are conditions. They must move into the home within a year of your passing, and they must make it their primary residence. They must file certain paperwork with the county assessor's office within a year of your death. And even then, there are limits on how much value can be excluded from reassessment. This is where many people get surprised. Even if your child qualifies to keep your tax base, there is a cap. If the value of the property exceeds a certain threshold above your current assessed value, the excess amount can be reassessed. This means your child's property taxes could still increase even if they move into the home. Now here's where the biggest change happens. If the property is not your primary residence, or if your child does not move into it, the property will be 100% reassessed to current fair market value. This includes rental properties, second homes, investment properties, and this can result in a significant increase in property taxes. Let's look at a simple example. A parent owns a rental property with a very low property tax base because they bought it a long time ago. They plan to pass that property to their child. Under the old rules, Proposition 13, the child could inherit the property and keep the same low property tax base. Under Proposition 19, that property will likely be reassessed to current fair market value, and the property taxes will increase dramatically. This changes the entire financial picture. This is why Proposition 19 comes up in almost every conversation about real estate planning, because it affects decisions like, should you keep the property? Should you transfer it during your lifetime? Should you sell it? Or should you restructure how it is held? These are not simple decisions, and they depend on your specific goals and your children's goals, your beneficiaries' goals. One of the biggest misconceptions is that putting property into a trust avoids property tax reassessment. This is not necessarily true. Proposition 19 looks at who ultimately receives the property and how it is used. So simply having a trust does not automatically preserve your tax base. The structure and the outcome both matter. When planning around Proposition 19, there are a few key things to think about. First, what is your goal for the property? Do you want your children to live in it after your passing, or is it an investment property? Second, what is the current tax base compared to fair market value today? The larger the gap, the greater the potential impact and increase in property taxes when you pass. Third, are there strategies that make sense during your lifetime? In some cases, families explore options before a transfer occurs. Another important point is balancing tax planning with flexibility. Sometimes trying to preserve a tax benefit can create limitations in other areas. So the goal is not just to minimize taxes, it is to create a plan that works for your overall situation. This is not just a financial issue. It can also affect family decisions. For example, a child may want to keep a family home, but the increased property tax may make that difficult to do, or siblings may have different opinions about what to do with the property. Having a clear plan helps avoid confusion and difficult decisions later. If you own a property in California, here are a few important questions to consider. Do your children plan to live in the property after your passing? Are you aware of the current tax base compared to fair market value today? How would a reassessment impact your beneficiaries? And does your current plan account for Proposition 19? Because these answers can significantly affect your outcome. If you own real estate and you are thinking about passing it on, this is something you should review carefully. At Allenby Law, we help families understand how Proposition 19 affects their situation and how to plan accordingly. We look at your goals, your property, and your options and help you create a plan that makes sense for your family. If you would like to review your situation or explore your options, you can reach out to us for a consultation. Because real estate is often one of the most valuable assets a family has, and understanding how it is transferred can make a significant difference for the next generation. And if you found this helpful, follow along for more insights on how to protect your family and your future.